Hey, everybody. Welcome back to Confidently Crypto, where we decode the future of money, law, and tech, one episode at a time. I'm your host, Dr. Tonya M. Evans, law professor, crypto educator, and author of Digital Money Demystified. And today, we're diving into one of the most overlooked but absolutely essential topics for anyone holding any amount of crypto or advising someone who does: estate planning in the age of digital assets. Now, I get it. Estate planning doesn't sound sexy, but losing access to hundreds of thousands or even millions of dollars in crypto because you didn't have a plan? I don't know about you, but that is absolutely worse to me. And this episode is part of our Web3 Ready Live series for Financial Literacy Month. And whether you are a holder, a hodler, a lawyer, a legacy builder, you will want to stick around in this episode because the truth is most estate plans and planners aren't ready for crypto. So let's fix that. And here's the good news. You've got one more chance to join me live for the final free webinar in the Web3 Ready Live series. It's happening this Thursday at 1 p.m. Eastern, and you can register right now at web3readylive.com. That's web, the number 3, readylive.com. We've covered what, we've covered why, and now it's time for the how to protect, plan, and profit in the Web3 economy with clarity, with strategy, and with confidence. So come for the webinar. Stay for the next level opportunity. I'll be unveiling exclusively to live attendees because information is power, but implementation is what builds legacy. So let's get Web3 ready. Now let's start with the hard truth. The estate planning industry was built for physical assets, real estate, bank accounts, even dusty old safe deposit boxes. It wasn't built for decentralized, cryptographically secured, pseudonymous digital money. And a traditional estate plan, you list your assets, you assign an executor, maybe name a trustee if you have a trust, and leave some instructions behind for your heirs. Your heirs go through probate. Your lawyer, if you need one, works with the courts, and eventually everything gets sorted. But with crypto, there's no help desk, no bank branch, no customer service hotline. And if your heirs don't have your private keys or access to your seed phrases, the words that are used to connect a wallet to communicate with the relevant blockchain, your crypto could be lost forever. That's it. No recovery email or reset. And that's not a theoretical problem. According to data from Chainalysis, over $100 billion with a B equivalent in crypto has been lost due to user error, forgotten keys, misplaced seed phrases, and inaccessible wallets. That's wealth, generational wealth, and it's just evaporating. And yet, most lawyers and financial advisors aren't asking clients if they even hold crypto. They're not documenting wallet access. They're not planning for fiduciary oversight of the digital assets. And that brings us to the 3 core planning pitfalls with crypto. That's a mouthful. So I'm going to take a breath, make sure you have something to write with, that you're in a quiet place, because I'm about to share some gems that I really want you to hold on to and to discuss with your family and the professionals who are helping you to build wealth in this generation and the next. So the 3 core planning pitfalls with crypto. If you take nothing else away from this episode, please remember these 3 estate planning pitfalls. Number 1, poor access planning. So let's start with the biggest and most common mistake: not sharing your access credentials. And in the world of crypto, there's no customer service line, no forgot password button. If your private keys or seed phrases are lost, your crypto is lost forever. And this isn't like losing access to a bank account. If the heirs don't have your keys, they can't access your wallets and they can't recover what's inside. So that old saying still rings true: not your keys, not your crypto, or not your coins. But of course, sharing private information doesn't mean posting them on a sticky note or tossing them in your desk drawer. It requires a secure but accessible plan that protects against both theft and loss. So let's talk about a few best practices. One, you could create a digital asset memorandum separate from your will that clearly outlines what crypto you own, where it's stored, whether it's a hardware slash cold storage wallet on some type of exchange, whether you use a multi-signature or what we call a multi-sig wallet, describing or leaving instructions about how to access it as well. You are storing these credentials in a secure vault, a password manager, or some fireproof safe with detailed instructions for your fiduciary. And one of my favorite things to do or to consider doing as I work through these issues, to appoint someone you trust, ideally someone with crypto knowledge who is fluent and trustworthy in the crypto ecosystem, or work with a crypto literate estate planning attorney. They are kind of few and far between right now, but I'm hoping it over time. And I'm certainly working with a lot of professionals, lawyers, trust advisors, bankers who are trying to become more crypto literate, or at least partnering with a professional like me who is. So planning is power, and failing to plan is a guarantee that your assets could vanish. And we don't want that. There's no point in focusing on autonomy and building the next wave of wealth if it's going to vanish in an instant. Number two is assuming that traditional trusts cover crypto. So let me explain what I mean by this. While traditional trusts can be structured to include digital assets like cryptocurrency, most boilerplate trust templates and even many custom drafted documents don't explicitly account for crypto unless the drafter or the client brings it up. And here's why that's a problem. Digital assets are fundamentally different from traditional assets like real estate or bank accounts. They require access credentials, private keys, seed phrases, wallet addresses to even identify or transfer them. And if your trust documents don't include provisions about digital asset management and access, your successor trustee may have no idea the crypto exists, lack the authority or instructions to manage or transfer or access it properly, may accidentally violate fiduciary duties due to volatility or improper custody, the prudential approach to management. And courts won't necessarily ignore crypto assets outright, but they might delay or complicate probate or trust administration if those assets aren't clearly addressed and accessible. And that's where the myth becomes risky, assuming that all assets are created equally and all assets are covered without specific language or planning. And that lack of specificity might lead to operational and legal headaches at a minimum. So, some best practices include crypto specific language in your trust documents, clearly define what digital assets are, cryptocurrencies like Bitcoin or ETH, or unique, special, non-fungible ones like non-fungible tokens, maybe domain names, ENS domains, for example, and authorize your trustee to manage them. Give your trustee the tools and the authority specifically to access and secure those assets. And this may mean using a digital fiduciary or appointing a co-trustee with crypto fluency. And document access credentials securely and separately held, and including instructions in a memorandum of intent or digital asset inventory, not in the trust instrument itself. Or if you have a will that is required to be filed, you would not want to put private information there. And that's why, work with your estate planning attorney, your advisor, in order to ensure that you give the right people access without making this information publicly available. Obviously, this is not legal or financial advice. I'm giving you some best practices to go and to speak with your professionals about this. If you are a trust and estates professional, trust advisor, financial advisor, CPA, having these conversations is critically important as well. Also, estate planning and administration is local, so you would check with your local, with your state authority for their testacy, meaning die when you die with a will, or intestacy laws when you die without a will. If your jurisdiction has adopted the revised Uniform Fiduciary Access to Digital Assets Act, that would require you to make sure that your trust gives the fiduciary lawful consent to access digital assets in compliance with that law. And third is, of course, ignoring tax implications. So, crypto taxes aren't just complicated, they're often misunderstood, even, dare I say, especially by professionals. And one of the biggest myths is that crypto is treated like cash because obviously it has currency in the term cryptocurrency, but it's not. The IRS classifies crypto as property, not currency, which means that every sale, swap, or gift can trigger capital gains or losses. And that includes buying a cup of coffee with Bitcoin or selling Ether for USD or even sending coins to a friend, receiving an airdrop. So, what does this mean in an estate planning context? If your estate or your heirs sell crypto after inheriting it, they'll need to calculate the cost basis and the capital gains. But here's the good news: crypto inherited through a will or trust generally qualifies for what we call a step up in basis, not the original cost that was the cost outlay, but what it would be valued present day, meaning the cost basis resets to the fair market value at the date of death. And this can significantly reduce the capital gains tax liability for your heirs. So, best practices is keep detailed records of when you acquired each asset, how much you paid, meaning the cost basis, how and when it was transferred. Be aware of the difference between gifting during life versus transferring at death, a testamentary gift that transferring at death. Gifted crypto keeps your original cost basis, which may result in more taxes for the recipient. So work with a crypto savvy CPA, tax attorney, etc., to ensure that your estate plan reflects the latest IRS guidance and prepare for changes like the new 1099 DA broker reporting rules set to kick in. Crypto taxes don't have to be scary, but ignoring them is a huge mistake, and that can cost your heirs big time. So let's take a moment to answer a few questions that came up when I talked about this topic during the second free webinar in Web3 Ready Live. And one was a comment that came after we finished. I bought Bitcoin in 2017, stored it on a hardware wallet. If I die, how does my family get to it? It's a great question. That is precisely why I'm talking about this today. And first, best practice would suggest that you securely document where the wallet is, what the password is, if there is one. All are different. Sometimes there's a combination of like a PIN code or password in addition to another step. And critically, what the seed phrase is, that 12 or 24 word phrase, is like the master key. You can lose a wallet or lose access to a wallet, but if you have the seed phrases, you could always set up your connection to the relevant blockchain and to your assets by just using the seed phrases to set up a new device. Now, I wouldn't celebrate if you lose your device, but as long as you have the seed phrase, you or your heirs would be able to set it up again. And that is critically important. Also, best practice: create a step by step access plan, store it offline, ideally in a fireproof, waterproof safe or a safe deposit box. Include instructions in your estate plan. And then I was having a conversation with a fellow attorney, and we were talking about how and when a lawyer should be asking questions about crypto. You don't have to be an estate planning lawyer in order to have this as part of your intake process. regardless if there is a business, if you're taking it in an IP client, certainly in custody issues or divorce proceedings, you must ask, regardless of the type of lawyer you are. If you don't ask, oftentimes clients aren't going to tell you. We are trained to have someone come into our office, tell us a long and winding story. Meanwhile, we're listening to spot issues and problem solve, and zealously advocate, right? So if we don't ask, they won't tell. And it's not even that they're not telling on purpose, but we need to make sure that we are doing our due diligence as professionals. And certainly if you're an estate planning attorney and you're drafting a plan or revising a plan, then it's already incomplete if you've not inquired about crypto. You need to go back to that client and have another conversation. Just like you'd asked about stock portfolios or out of state property, you should be asking about digital assets, including crypto, NFTs, tokenized assets. I'm assuming that you're already asking about intellectual property, for example. This is the same thing that you need to do in the digital asset space. And finally, what do you need to do right now? Okay, so these are some things that you can do today to begin to make your estate plan crypto ready. One, ask the right questions. Whether you're planning for yourself or your clients, ask, do you hold crypto? Where is it stored? Who knows how to access it? What type of transaction tracking are you doing? Are you using Coin Tracker or something of that nature so that you can prepare for tax time by automating the process of tracking transactions with some type of software or some type of program? To document access clearly and securely, that's writing down instructions, but don't store them on your Google Drive. Use encrypted storage, safe deposit boxes, or services like Casa or Safe Haven that specialize in crypto estate access. Update your legal documents. So that's add crypto specific language to your wills, your trusts, your powers of appointment. Appoint a crypto literate executor or trustee or special advisor. And yes, these people exist. We exist, just waiting to help. Many professionals are not trained in this super special and specific area, but there are many of us who work in tandem with professionals to make sure that their clients, their customers are well taken care of. Also plan for incapacity, not just death. It's not just about dying, it's about becoming unable to manage your own assets, your own keys. A proper power of attorney, for example, or power of appointment as well. But here, specifically for power of attorney, when someone is acting on your behalf either during periods of your capacity or incapacity, depending upon the language of the power of attorney. So a power of attorney document should specify how digital assets are managed during incapacity as well. And finally, get professional help. This is not the time for do it yourself. Work with lawyers and advisors who understand crypto. Not that they've heard of it, not that they bought a little of it. Those folks are just enough to be dangerous. I'm telling you what I know. Steer clear of them. If yours doesn't, find one who does. And finally, if you listen to last episode or you are connected with me on LinkedIn, then you have seen that after almost 20 years in the legal academy and 5 incredible ones at Penn State Dickinson Law and the Penn State Institute for Computational and Data Sciences, I'm leaving full-time teaching to go full steam ahead in Web3 consulting and education. This is not anti-law by any stretch of the imagination, but because of it, because the law has to evolve and I want to be a part of that evolution. So I'm focused now on 3 areas in particular. The first, of course, is education. And through my Advantage Evans Academy, my Substack, I'm demystifying crypto for professionals and institutions. 2, advising. So working with companies and DAOs, family offices, and lawyers to build compliant, forward-thinking strategies in Web3. And 3, of course, speaking and thought leadership from Capitol Hill to crypto Twitter and everywhere in between. I'm here to shape the narrative and drive policy that benefits everyone. that benefits access and inclusion and innovation. And I will continue to host webinars and trainings and continuing education on site as well. If you want to learn more, head over to proftonyaevans.com. That's prof like professor, Tonya, TonyaEvans.com, and sign up for access to any replays that you missed from Web3 Ready Live and participate in upcoming sessions and opportunities. And you are invited to the final 2-hour training and Q&A to bring all of the sessions to practical applications and go from the what and the why to the how in a very special VIP session. You'll learn more about it this Thursday. Register for the webinar to receive additional details and early access. You'll get expert insights, downloadable worksheets, bonuses, and replays are available for the entire series, but only if you register. So head to web3readylive.com or proftonyaevans.com to grab your seat. And final thoughts for today. The future of wealth is digital. The future of inheritance is decentralized, but that future only works if we plan for it intentionally, securely, and smartly. So whether you're holding a little or a lot, start the conversation today. And if you're a lawyer, advisor, or executor, start asking better questions like yesterday. Crypto estate planning isn't about just protecting coins, it's about protecting legacies. So until next time, be good to yourself and others and stay confidently crypto.